Criminal liability. So in law, criminal liability can be defined as a liability or responsibility of a person for a crime when he or she has acted with criminal intent. So a person's intention, okay, with what intention they have committed a crime or taken an action is considered here. Okay, as opposed to acting accidentally or lacking the ability to act deliberately, that doesn't matter here. Accidental cause will not be considered as a criminal liability, but intentional causes, intentional actions are considered under criminal liability. If the liability is hence proven in the court, then one will be sentenced accordingly. So these are the Indian section penal codes from page number 102 to 103. Okay. So these sections in detail I have taken in previous class. Okay, article wise I have taken most of these sections. Okay, and more than these sections were also being discussed in the previous class few weeks before we have done. So these sections, just go through it once, just understand the concept of it. No need to memorize a section particular number and what exactly is being defined under that section. That memorization is not required here. Okay. Only these sections in detail we have discussed in previous class. So moving further, coming to criminal negligence, a physician can be charged if the patient dies during treatment and cause of death is proven to due to malicious act or intention. So every surgery ever or every time the patient is under anesthesia or the patient is under sedation, there is a certain amount of risk that could cause death. Natural causes, okay, natural causes or natural risk that is affected by the surgery that could lead to death, that is always present. So if a patient dies because of those natural causes, you cannot sue the doctor, or the doctor is not liable here. But if the patient dies because of negligent acts or malicious act, intentionally doctor did something that led to the death of the patient, okay, that will come under criminal negligence. Okay, so a doctor cannot be held responsible until he or she was negligent, or he or she was incompetent. For example, an orthopedician, an ortho surgeon doing a nephrology surgery. Okay, so they are based on their specialty, they are incompetent to do that. Okay, a person who has done BHMS, okay, Ayurveda specialist, okay, they are doing a general anesthesia based surgery. Okay, that is incompetency. Okay, disregard for if the doctor's actions or phrases or acts deliberately showed that they had utter disregard for the patient's life and safety. Okay, such under such circumstances also a doctor can be held responsible. Okay, and until and unless the doctor shows these traits, their actions were completely negligent, they were incompetent to perform a specific treatment, but still they went ahead with that, or they didn't had their actions didn't had any regard for the patient's life and safety. Under such circumstances, a doctor can be charged. Otherwise, not. Okay, so these three areas has to be proven in the court of law. Okay, only then a physician or a doctor can be punished. Next, coming to gross negligence. Okay, so gross negligence first is the when does you can you sue a doctor under gross negligence? First is when a doctor is incompetent. Okay, when they do not perform in their particular. Am I audible to all? So under which, what constitutes gross negligence? Okay, what constitutes gross negligence? Because under gross negligence as well, a doctor can be charged. Okay, doctor can be held up in court. So what all areas come under gross negligence? So first is incompetency. Same, if you are not competent enough to carry out a treatment, you have not well researched, or you do not have the knowledge of that particular medical science or that particular medical practice. If you do not have the knowledge of that, you are not supposed to take any rash actions in that particular area. So that is incompetency. If you try to venture into a specialty of which you do not have a proper service experience, proper knowledge based experience, or practical experience, the doctor is not supposed to practice in that particular field. So if at all the doctor does practice and it causes gross harm to the patient, they can be held up in court. Okay. Then inattention. uh, when the surgery is going on, okay, if you notice, every surgeon will have their attention on the patient's vitals, okay, the patient's statistics on table when the patient is sedated, or the patient is under anesthesia. Okay, the patient can't say anything, but the body vitals, the vital statistics of the patient will communicate much more. Okay, so attention to these details, attention to these details. Or if at all, uh, uh, because of gross negligence or because of the doctor's inattention, okay, the patient went into a state from where they cannot come back. Okay, in case of death, or in case of complete loss of a motor function, etc., just because the surgeon was not attentive enough. Okay, in the during the surgery, that could also lead to gross negligence. Okay, there is also an example of gross negligence in UK. A case took place, okay, in which what happened was the defendant, that is the patient, the patient died actually. So their relatives went okay ahead with the case. Okay, so what happened here was a small nasal operation was to be taken up, and when the patient was under anesthesia, okay, the tube, anesthesia tube, it dislodged from the area. And what happened was the surgeon was carrying on with the surgery. The anesthesia tube dislodged, and there was no oxygen supply to the patient who was on table. Okay, so what should actually the surgeon do, even if the surgeon knows that the patient is put on oxygen, but still the SpO2 levels has to be checked constantly. Okay, so here the doctor didn't do that. Okay, the doctor just carried on with his work of surgery, but didn't pay any attention to what actually is happening. Okay, as when the patient passed away, the patient suffered a cardiac arrest on table because of deprivation of oxygen and died on the table. Okay, the doctor was then convicted of manslaughter. Manslaughter means homicide or murder. Okay, and even when the it was appealed in the House of Lords. In UK, you have the House of Lords, like how we have the Supreme Court here. They have their House of Lords kind of legal tires. Okay, so even the doctor's appeal was rejected. Okay, it was considered as a murder because of inattention to detail. Okay, so that's an example. Indifference to patient's safety, not being not taking decisions to keep patient's safety intact. Okay, just to do your work, you want to just carry out your work. You are not considering what the patient may go through. Okay, the what the patient wants, what the patient may go through. When you don't consider all those facts, okay, when your actions speak, when your actions speak that you do not care about how well your patient would be, or how your patient would feel like, okay, you do not care about that, when your actions speak that, you could be tried in the court. The ignorance of science of medicine and surgery. Okay, when you do not take decisions based on evidence based medical practice. Okay, those who are in the clinical field, they would know nowadays the majority of the decisions what a doctor is supposed to make is completely based on evidence based medical practice. Okay, if you deviate from that and it led to a manslaughter, if it led to death, or any gross negligent cases, you could be tried in the court of law. Okay, so any deviance from the evidence-based medical practice also could land you in a court. Then applications and selections of remedies, the way how you choose your treatment, the way how you apply your treatment. Okay, if you are not competent in it, and you do not like for a disease a treatment a should be prescribed, but you want to be more creative, you went again ahead with some other kind of treatment. Okay, and it backfired. Okay, so in that case also, you have done a negligent act. Okay, lack of proper skill, under skilled and still practicing on live patients. Okay, that could also land you up in court. Okay, so these are the examples under gross negligence. Then comes the burden of proof and the chance of error. Okay, so burden of proof completely lies on the shoulders of the patient here, or the defendant here. Okay, whoever is a defendant, the burden of proof is on them. They have to bring the adequate proof. Okay, which showcases that the doctor could be at doctor is at mistake. Okay, which proves the doctor's mistake. So that kind of proof has to be brought in by the defendant. Okay, so any proof of negligence, carelessness, insufficiency, okay, these all generally lie on the shoulder of the complainant, that is a defendant here. Okay, so and also our laws, it requires a higher standard of evidence, because for every small level of proof, you cannot put the doctors in jail, because you will be losing a lot of skill out of the healthcare system. Okay, so the courts will try their best to keep the doctors functioning in the society, and only in very rare cases, okay, when the evidence is so high, the evidence puts the doctors practice at stake, only in such cases the doctors are tried, jailed, or they are removed from practicing. Okay, otherwise the court of India will try their best to keep the working professionals in their workplace, because already we are short staffed as a country. India as a country, but when it comes to healthcare system, we and the population which we are tending to, okay, we are already short staffed. Okay, and on top of that, with medical legal cases, for all small petty cases and small petty negligent issues, we may just ask the doctors or the hospital to pay a compensation, but rarely a doctor could be put in jail and out of practice. Okay, so the evidence required in the court of law, the standard of that evidence is quite high. You have to bring a very substantial, strong evidence which supports your claim. Okay, the patient must establish the claim against a doctor. The patients can also use other doctors as well through second opinions. Okay, they can cross verify the proofs and the documents from other doctors as well, other healthcare systems as well, to prove their to prove the validity of their complaint. Okay. Next is criminal negligence for a doctor, how it affects. So the doctor has to prove what all actions he took, or what all judgment he took at that particular point of time. It was considered the best way out. Okay, so so the doctor has to prove that in the court. Okay, at that particular point of time, when a decision was being taken up, why the doctor went ahead with this particular decision, why not decision B? Okay, why decision A, why not decision B? So the doctor has to prove his innocence, his or her innocence in the court of law, by proving why did the doctor took that particular judgment. Okay, why did the doctor went for that treatment instead of the other options. Okay, so what are actions the doctor may have took in rendering a case, every action has to be proved. The judgment of every action, the rationale behind every action, the doctors has to place in front of the court. Okay, the doctors are not liable for an error of judgment. Okay, misdiagnosis. Okay, error of judgments, like mistakenly you took some other issue for some other case. Okay, so those things will not be uh, viable to try a physician or to try a practitioner in court. Okay, so error of judgment is not enough basis of proof to try a doctor. Anyone can do a mistake. Humans are put to do a mistake. Okay, mistake of judgment. Okay, what actually you see is always not the truth. Okay, sometimes the doctor may misdiagnose a disease condition. So misdiagnosis is not how you can try a doctor. Prima facie evidence from credible opinion is required. Okay, prima facie means first evidence, first a hand of evidence from a credible opinion. Could be the doctors who are working in the same hospital, or specialists who have treated or who have a commendable experience in treating the same kind of case from other state or other hospital. So that they become a credible opinion here, because the court of law, the lawyers who are sitting there, the judges who are sitting in the courts to judge a medical practice, they may not have the correct knowledge of medical science. Okay, but they can completely trust the opinion of a very credible source who is practicing the same medical field of science from a long year, from very long time, etc. So they will be considered as a credible opinion. So based on their opinion, okay, judgment can also be passed. So doctor can be arrested only if the negligence is proven. Just because an FIR has been raised against you, okay, just because a police case has been registered against a doctor, doesn't mean the police can go and handcuff the doctor, put the doctor in jail. The negligence has to be proved. The case has to be proved. The sentence has to be given by the court. Only then the police can come and interfere and take the doctor away from his or her practice. Otherwise, the law enforcement is not supposed to disturb the or doctor in their workplace while they're serving the community. Next, coming to certain safeguards which can reduce the risk of allegations by the patients. Okay, how the doctors can put on a guard, how the in which all areas the doctors has to be much vigilant when it comes to criminal negligence or criminal liability, and how to protect themselves so that they don't fall prey to these areas all over again. Okay, so first is accepting patients. When you see a patient for the first time, when you take their medical history examination, let's say for example a patient who is in the final stage of cancer, there is everything has been tried and done and nothing else is remaining. You have exhausted all the possible treatment options here, and the patient is in the final stage. Hospice is the only way ahead. Okay, end of life care is the only way ahead. Okay, and sometimes the family is adamant. The family is adamant. They think that no, you can still save my loved one. Okay, please do something. Okay, and just for the sake of giving them false assurance, the doctor cannot accept the patient. If the doctor accepts that patient, okay, I will treat him, I will try to make him better. In such pretext, if the doctor accepts the patient, and if the patient dies off, then definitely the doctor can be liable because they gave false hope, etc. Okay, so don't accept the patient which you know that uh, their treatment is beyond your capacity. Always try to establish that first. Whatever cases are given to you, is it under your capacity to treat or not? Okay, so accepting the patients, be careful about that. Then document complaints, all the complaints, investigation, and every advice you have given for every other case. Okay, whichever patients you have come across, in the first meeting itself, what are complaints and what are issues uh, they have listed out to you. Write it down properly. Okay, and what are investigations you have prescribed to diagnose the disease condition further, that also has to be written down. Okay, because if at all you have not mentioned the complaints and investigations, it could be used against you later. Okay, so the best when you DPR means the doctor patient relationship. Okay, the doctor patient interpersonal relationship, that is DPR. So when you maintain doctor patient relationship with each of your clients, each of your patients, be at your best communication as possible with each one of them. Do not bring your bad mood from your work or bad mood from your home and let that affect your doctor patient relationship. Okay, because the patient may construe it in a negative way, that this doctor is very rude to me, doesn't talk to me properly. How can I trust my life with this doctor? Okay, this doctor will not care about me. He is not considerate about my safety or my well-being. Okay, if that kind of thought creeps up into the patient's mind, and still because of some chances that patient decided to go with this particular doctor, something bad happened. Keeping this grudge in the mind, the patient may charge a case against you. Okay, so avoid that. So be in your best ability to maintain your doctor patient relationship. Counsel clearly and honestly, especially when you are counseling the relatives. Okay, the treatment options, the what difficulties you may face as a doctor while treating this case. Okay, all these areas of unseen issues. Okay, these all things has to be counseled clearly to the patient as well as to the family as well. Both of them, the relatives and the patient, should know what risk you possess as a physician, what risk they possess as natural causes. Okay, it has to be clear to them as well. So treatment option, do not hide any treatment option. Even if there is, in case of cancer treatments and all, if there is a study going on which has the potential to benefit your case, make them aware of that study, make them aware of that research as well. They could be the subject for that research as well, human subject for the research as well. So anything which is in your knowledge, which is within the boundary of your knowledge. Okay, even though that if the treatment has a potential, okay, you cannot give a guaranteed number, but even if it is a small potential, let it be known to the patient and the patient family. Never overstep one's qualification. Always perform under your qualification. Okay, never try to step up or try to indulge in other specialities if you are not aware of it. Communicate frankly with the relatives. Same thing, don't hide anything from the relatives. Sometimes some bad news you can't give to the patient, but the relatives are strong. You can ask them to break the news to the patient as well. So if you can identify the relatives are strong, okay, giving them the news will not have any negative impact on the patient's health. Okay, so be frank with the patient's relatives. In some cases, when the patient's health is very tender, in case of cardiac arrest patients and all, you can't break a bad news in front of them just when they are healing from a bypass surgery or something like that. Okay, you can't just break a bad news in front of them. You know that any stress could possess a risk of loss of life. So under such situations, you may have to hide certain aspects of information from the patient just to protect them. Okay, just to protect their health. So in those cases, be frank with the relatives at least. Ensure well equipped facilities, especially when you are giving a treatment, you went for certain options of treatment, and certain specific equipments are required. Only if your facility has those equipments, you can guide the patients to go for that particular treatment. If your facility does not have this particular equipment, you also can guide the patient to the other referral hospitals which are known for this particular treatment, and they are well equipped. Okay, you can refer other facilities as well which are well equipped, which can solve the problems of the patient. Visit the patient regularly. Okay, if even if the patient is inpatient, is going to be discharged on the very same day, but still Even on the day of discharge, visit your patient. Do not miss any day of inpatient visits. No contradictory case notes. For example, if you have a team of specialists treating a patient, okay, consultant, physician, surgeon, physiotherapist, okay, so you have a team of people who are taking care of a single patient. Everyone's note should have a similar scenario of the patient. Do not show any contradiction. Physician A is telling something, specialist is telling something else about the case. Physiotherapist has some other ideas about the patient. So all four of them, all the four main players in a healthcare team are speaking something different about the same patient. That kind of situation should not arise. Okay, everyone should be on the same page to understand at what level the patient is in terms of their health and how can we alleviate the patient's condition. Okay, timely referral. Just to make more money, do not keep the patient in your hospital for more days. If you know that your facility is not well equipped, and keeping the patient in your hospital or ICU for at least one more day, okay, you may make the money out of it, but the patient may be at the risk of getting delayed treatment, and that could lead to death as well. So do not play around with that. Okay, if you know exactly that your institute is incapable of serving this patient, but there are other institutions near you, near your hospital, or near the in the state or other city, refer your patients immediately to those particular hospitals. Okay, don't be profit minded in these cases. So that's all about criminal liability.